Good morning again. Good morning again. Ladies and gentlemen, please. We come to our final session now. We will be presenting and discussing with you the topic of market conduct. Before we start, let me just make a couple announcements. Please, when you ask a question, please use the microphone because all your comments are being recorded, so for us to go back to them and be able to analyze them. Number two, if you need anything from the CMA in terms of the presentations that you have seen or to send us your comments and remarks in writing, please use the email. If you don't have it, we have our staff here to help you do so. The final subject, like I said, is market conduct. The main purpose of the market conduct is to promote the confident and informed participation of businesses, investors, and consumers in the financial markets. On the other hand, we promote and facilitate the development of fair, efficient, and transparent financial markets. And another title for this would be a code of behavior in the market. I have to my right our colleague and head of our legal department, Maitre Kaline Aoun, and you all know already Mr. Carson and Mr. Ghalayini. Kaline and John will be presenting the subject simultaneously, and then we will open the floor for questions. Please.
The market conduct regulation covers the following topics: purpose and background of the regulation, insider trading rule, market manipulation rules, and false and misleading statements, and the conduct of the approved institution when trading in the market. The purpose of market conduct regulation is to provide for a safe, fair, and transparent market by setting a detailed legal framework for the major misconduct in the markets. There are insider trading, market manipulation, false and misleading statement, and also by setting certain obligations that the institution should respect while conducting trades in the market. The legal background of this regulation is Law 160 that introduced for the first time the concept of insider trading, and that established also for the first time the rules that govern insider trading in Lebanon. And it's also Law 161 that vested the CMA with the duty of protecting the investor from any illegal or unfair practice, including insider tradings. That led to the decision number 6 that some of you know already on insider trading issued by the CMA. The market conduct regulation will replace this decision when it's implemented. When the market conduct regulation is implemented, it will replace decision 6. In the meantime, decision 6 is still applicable and you should comply with it. After going through the purpose and the background, we get to the insider trading topic. Insider trading can be defined as the prohibition of dealing directly or indirectly while in possession of an inside non-public information related to the traded security. Although the prohibition applies to any trader in the Lebanese financial market, the regulation is different when this trader is an insider. But before analyzing this difference, we should maybe go through some definitions that will highlight the real scope of this prohibition. For example, for an information to be considered as a non-public as an inside non-public information, it has to relate to the traded security or an issuer of the traded security. It has also to be not public at the time of the trade. It has to be precise and accurate, which exclude rumors, and it has to be material. We understand by material that this information will likely to have a significant effect on the price or the decision of the investor. An insider, according to this regulation, is a director, an officer, a manager, or of the issuer, or a close relative to those persons we just named. And also, any person who obtains inside information through a business relation with an issuer or an insider. For example, a lawyer. No, it's too close. The law also, the regulation also defines the traded operation. The traded operation, according to this regulation, includes direct or indirect operations, such as, for example, trading through an owned entity. It also includes trading for another person or encouraging a trade. And it also includes trade in related securities, for example, an underlying of a structured product. It is also important to emphasize on the fact that this regulation only applies to securities that are traded, to traded securities. And we understand by traded securities, securities traded on an organized Lebanese financial market, whether it's an exchange or an OTC, when it exceeds 20 shareholders. I know this will trigger many questions. This OTC requirement and this 20 shareholders is still maybe ambiguous to you. So an example of a share that will be considered as applying as under this regulation is a Casino du Liban share that is proposed in the newspaper. Because first it's a public trade, and then because Casino du Liban has more than 20 shareholders. While maybe other transaction whereby a person will call another to sell a share, to propose a share for selling, will not be under the insider trading regulation. As mentioned earlier, there's a difference regarding this regulation when the trade is made, thank you, by an insider or by a non-insider. It's more strict, obviously, when it's an insider. An insider is prohibited from trading while in possession of inside information, while any other person is prohibited from trading while in possession of inside information when that person knows for a fact or should have known that this information was an inside non-public information. This is very important in matter of investigation because we have here an assumption that the insider is always aware of the nature of the information while it has to be proven regarding any other person. This regulation also prohibits tipping, not only trading, so the insiders are not allowed to disclose the inside the non-public information they have. They are not allowed either to advise somebody based on this information, and any other person also are not allowed to disclose the information they have when they know that they are holding a non-public inside information. The purpose of this regulation is not only to prohibit and to sanction insider trading, it is also to prevent it. Therefore, we have in this regulation some notification duties that the approved institution should comply with. We have three kinds of notification. The first one is the list of insiders. Every approved institution should make a list of the clients who are insiders and notify the CMA with that list. Here also we have to keep in mind that we are talking about the insiders of traded issuers, and not any CEO of a company will figure on this list. This list also should be updated. And the other notification is that any institution should notify the CMA of any trade the insiders on that list will make on the issuer stock, and then again not on any stock or any operation they will make. The third notification is regarding suspicion that the approved institution will have on a certain operation. They will have to notify the CMA right away that they have this suspicion. Another provision that aims to prevent insider trading is what we call the blackout period, and this is a duty on the issuer. An insider of an issuer and a close relative to this insider are simply prohibited from doing any trade on the stock of this issuer or the security of this issuer for 10 days before and 3 days after the release of the financials of this issuer. For those who know already the decision number 6, this blackout period was already in this decision. However, it was modified. The period that follows the release of the information was reduced from 10 to 3 days. And the whole prohibition was limited in this regulation to the financial instead of any material information that is applicable today in Decision 6. The issuer must adopt internal policy regarding the blackout period and the insider trading in general to prevent it. And hopefully it should become part of the corporate culture of this issuer and not only a prohibition dictated in the regulation. That's it regarding insider trading. I hope it was clear and useful and you don't have any question. And now, that was my joke of the day. And now John will
Okay, before we
with
have questions about insider trading, let's talk about market manipulation. Obviously, having rules against market manipulation is core to market integrity, to fair markets, and those aren't covered specifically in the law, but we have them in this regulation. Basically, we're start by defining manipulative and deceptive trading practices. A couple of things are deemed to be in those categories. Those are fictitious trades or a trade where there's no change in the beneficial owner. And the concept of a fictitious trade, it really means a trade that wasn't made for a legitimate investment or trading purpose. Those two things are different. Not all trades are for investment, obviously. They could be, for example, for arbitrage or some other reason, but they need to be a legitimate trading purpose. Otherwise, we say that they're not real from a market integrity standpoint. They were created really to deceive people. An artificial price really means a price that was a result of factors other than legitimate supply and demand in the stock, legitimate bids and offers in the market based on accurate information. This area, I can tell you from a ton of personal experience, is fraught with difficulty because it's always a question of fact and of judgment whether a price is artificial and whether a manipulation has occurred. In one of my other lives, I do write expert witness reports in securities litigation and enforcement actions as to whether a manipulation has taken place in a security. And it is often complicated. You must take into account all the factors that influence the market, which is not only the orders and not only the trading, but other things such as circulation of corporate news releases, research reports, and other so-called investor relations activities. But at the end of the day, you're looking for patterns of activity. That is what you're looking for. And you're looking oftentimes to see if these trades were prearranged or planned in a way to create false volume or a false price. So, for example, one of the cases I'm working on right now seemed to be pretty obvious because over an 8-month period of time, a group of 10 people was organized to not really increase the price of a stock in an obvious way, but just to maintain the price above a certain level. And when you look at it, the level was $7 in this case in Canada. When you look at it, they entered the market every time it looked like the security was going to fall below $7 in price. But it was often a different person. Different persons would be active at different times. Some of the group would disappear for a period of months and then come back again, all in an attempt to disguise what is going on. So the regulation here really sets out examples of what a manipulation might be, but it's not exhaustive. So the bullet points on the screen, those are examples. For example, entering orders for the purpose of setting a price or to set a high close price. Setting a high close price is, you could say, a minor manipulation because usually the change in the price is not huge, but nevertheless, it is usually done for purposes of deceiving the market and other investors as to the value of the security. A more expansive and significant type of manipulation that unfortunately we've had a lot of experience with in Canada is the so-called pump and dump scheme. In a highly speculative, very junior company that probably has minimal or even next to no business operations, you see groups organize themselves to pump the price of this stock up, to create volume in the stock, to attract excitement around the security and get other investors to pile in. And then when they've achieved their purpose, the group drops out of the picture, they no longer trade, the public, the price of the stock falls, and the public is left holding the bag. The securities have been dumped on the public, and the insiders walk away with the profits. So those are just a couple of examples of the manipulation. The prohibitions are twofold. First of all, on any practices that any person, we're not talking only about securities industry professionals, any person knows might result in a misleading price or a misleading impression of interest in the security. And then there's the prohibition on orders and trades. If any order is entered or any trade is made not for the purpose of getting a fill, not for a legitimate investment purpose, but apparently for creating one of these false perceptions, that is obviously prohibited. So again, a couple of examples of patterns that you might see. One is what we call circular trading. This is trading by a group of persons who just push stock around in a circle, keep trading it progressively at higher prices, but there isn't any new money coming into the system. The money just flows around the circle until they achieve their purpose. Another thing that you might see is when people want to maintain a price at a certain level or to push the price up a bit, they only trade the minimum volume necessary to achieve that purpose. They never trade more stock. So these are some other examples. Moving on to false and misleading statements. The purpose here is really just to prevent, again, any person from making false public statements in an attempt to effectively manipulate or create a false impression of the value of a security. It must meet the specific requirements of the definition One, it's false in a material way. Two, it misrepresents a material fact or omits to include a material fact. Again, it's a prohibition that applies to any person. The person also has to have had the purpose of creating this false impression. So intent has to be proven in any enforcement action. And the person also needs to know that the statement is false or misleading. So, while it may appear that this regulation is potentially a bit dangerous because it could catch many situations, in fact, when you look at all the elements that have to be proven, it wouldn't catch that many situations. Then we have a certain set of conduct rules that only apply to approved institutions in carrying on securities business. Number one is an example of what we call a gatekeeper obligation. A gatekeeper is the institution as a licensed professional firm has an obligation to help to protect market integrity. And so, therefore, they should not process orders that, for example, there are reasonable grounds to believe that an insider trade is being made or a manipulation is being pursued. That gatekeeper obligation is also relevant for purposes of market supervision with the authority. Now, obviously, an individual representative of an institution is not going to make a decision like that on his or her own. I mean, any decision like that would obviously involve supervisors in the firm and compliance. Then we have the statement of client priority. Seems to be obvious that you should give priority to your client orders. We may need to beef up the wording of this rule somewhat because it only makes the simple statement. Obviously, we're talking here about situations where the firm's order could compete with the order of the client. So, same stock, it's both buy or both sell, and there's price competition for a fill. You also need to be aware of the client order if we're talking about an individual person in the firm. Thirdly, we have the best execution obligation. There are really two situations there. The first is that for a small order, it's usually considered just to be the best available price in the market, whereas for a larger order that could not be filled immediately in the open market, you need to consider the time that's required to fill that order and basically at what price it can be filled overall when the full trade is completed. I'll pass over records of orders. I think that's obvious. In terms of the rule, client orders must be executed ASAP. Basically, that just means you can't hold an order on your desk for some purpose, hoping that something will change or that you're going to pool it with another order. You need to put that order into the market and execute it, unless it is a situation where the order can't be filled in the market, and then you might have to find a liquidity provider based on the size of the order to fill it. That is relevant to point number 6, which says that aggregation of orders is prohibited. Again, orders should be executed as entered. There should be an audit trail whereby you can track the receipt of an order through execution through to confirmation of that trade back to the client. Churning was alluded to in the earlier session this morning. Again, that's a judgment call because what is excessive activity for the purpose of generating fees in an account depends, whether it applies, depends on the nature of the client, the nature of the portfolio, and what is suitable. Front running is an important concept. Basically, it prohibits trading ahead by an institution or one of its registered persons who knows about a client order, knows that that client order will likely move the price of a security when it is traded, so trades for his own account ahead of the client order in order to make some money, in order to profit from that information. That is certainly a more serious offense than violating client priority, because client priority is only trading in front of an order without regard to whether any profit might be obtained, just to get the fill first. Front running is where it's done for the purpose of taking advantage of sensitive market information at the expense of your own client. And a couple of final points. Trading ahead of research reports is prohibited. This is a report from your own firm, your own institution. If you're in the business of issuing securities research to clients, you need to give your clients an opportunity to receive and respond to that research before making any proprietary trades based on your recommendations. And finally, where there are stock recommendations, the rule states that you can't advise an individual representative, for example, can't advise a client to make a trade that is contrary to his firm's research, at least without disclosing that that research recommendation exists. There are always going to be clients who don't accept recommendations and take a different view on a security. No problem. But they need to be advised that the firm's recommendation was to the contrary. So that is our summary of market conduct.